Okay, welcome to Professional Responsibility, Unit Week 12. That was a somewhat spotty version of Beethoven's Fifth. I don't know whether it was Bluetooth or the YouTube, not sure. All right, let's get into this. Professional Responsibility, Unit Week 12. This is supplemental lecture video for your reading assignment, which was for week 12 was chapter 11 of your textbook. Let's get started. This has to do with mostly the client-lawyer relationship and conflicts of interest, but there is some review of previous rules that we've already gone through that are interconnected with these conflict of interest rules as well. So the first, as you know, Rule 1 are the client-lawyer relationship rules under the model rules of the MBA, and 1.2 was implicated in this week's reading and has some interplay with the conflict of interest rules. And 1.2 is the scope of representation and allocation of authority between the client and the lawyer. We've gone through this rule before. Remember that the client is in charge of the objectives of the representation. That in a civil suit, the client determines whether they will settle the matter. In a criminal case, the client will determine, and in a criminal case, it's the defendant, as to what plea will be entered, whether to waive a jury trial, and whether the client will testify. The lawyer is, however, in charge of the tactics. So if the client is in charge of the objectives of the representation, the attorney is in charge of the tactics to meet the objectives of that representation. Comment 1, paragraph A confers upon the client the ultimate authority to determine the purpose to be served by the legal representation within the limits imposed by law and the lawyer's professional obligations. The decisions specified in paragraph A, such as whether to settle a civil matter, must also be made by the client. Okay, so hopefully that's a good review, and that you are all aware of that. The bifurcation between the client's authority concerning the objectives of the representation and the attorney's authority concerning the tactics in order to meet that representation. Communication, this is also implicated in this week's reading, but this is also review. It says a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. So, for example, if the opposition proposes a settlement agreement, then you as the attorney must promptly inform the client of that settlement agreement. Rule 1.5, fees. A lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. 1.5 is implicated when it comes to some of the conflict of interest rules concerning entering into a business transaction with the client. But sometimes such a transaction is actually the payment of fees. Okay, so the rules get into that. The conflict of interest rules get into that. Always remember that the fee, first and foremost, must be a reasonable fee as well as expenses. A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraph D or other law. And remember, paragraph D prohibits contingent fees when it comes to family law type adjudication, such as divorce, property sharing and arrangements, or property distribution, and I think in most cases, or in most jurisdictions, child custody. Okay, so, and also a defense lawyer in a criminal trial cannot charge a contingent fee. And remember, if you're going to charge a contingent fee, it must be in writing up front. That's the difference between a contingent fee and, say, an hourly fee. or some other kind of fee that is not contingent. All right. Okay, now we get into the conflict of interest. Conflict of interest for current clients. So this has to do with, for example, you don't want to represent two clients in the same matter, or represent one client in one matter and represent somebody else adverse to that client in another matter, because it will pull the attorney in two different directions, and therefore there are rules when this can occur, and let's go through those rules now. Rule 1.7, conflict of interest, current clients. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client. So that's kind of serving two masters, and for different outcomes. So you don't want that, or the disjunctive. There's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Okay? So you should not represent when this concurrent conflict of interest exists. However, B will allow you to represent the client. It says, notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if, and it says, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. So on an exam or on the MPRE, if the lawyer reasonably believes they can provide competent, they're not usually going to ask you to determine whether the lawyer is able to do that. They'll normally state in the fact pattern that the lawyer reasonably believes that they are able to do that. Okay? And also this other thing, if the representation is not prohibited by law, they'll either tell you in the fact pattern or not whether it's prohibited by law. If they're silent about that, then it's not prohibited by law. So here are the two parts of the exception. First one, the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. Okay, so it cannot have that. So the lawyer must reasonably believe that they can provide competent, diligent service. And three, and then also each affected client gives informed consent confirmed in writing. All right, so you can have a concurrent conflict of interest and you can represent the people. You should not represent them, but you can represent them under B if 1, 2, 3, and 4 are met. Let's look at some of the comments to Rule 1.7. Comment 6. So that's what this is about. Loyalty to a current client prohibits undertaking representation directly adverse to that client without the client's informed consent. Thus, absent consent, a lawyer may not act as an advocate in one matter against a person the lawyer represents in some other matter, even when the matters are wholly unrelated. I mean, basically what they're saying is, look, you always want to be on the side of the client. If another matter comes up that puts you adverse to that client, then you have a concurrent conflict of interest, and thus you probably should only represent the client in the matter in which you are the advocate for that client, or well, there's other rules, such as 1.6 and other things, which you can't go against that client. All right, let's keep going. So comment 7. Directly adverse conflicts can also arise in transactional matters, such as negotiating contracts, for example. That's a transactional matter. For example, if a lawyer is asked to represent the seller of a business in negotiations with a buyer represented by the lawyer, not in the same transaction, but in an unrelated matter, The lawyer could not undertake the representation without the informed consent of each client. Okay, so you're representing one client. I guess it's a transactional matter. It's a contract. It's the sale of a business. And the person who is selling the business to your client is someone that you represent in another matter, even unrelated. Well, the lawyer could not undertake it. Each client must give consent. Okay? All right, comment 10. The lawyer's own interest should not be permitted to have an adverse effect on representation of a client. That includes personal interest. For example, if the probity of a lawyer's own conduct in a transaction is in serious question, it may be difficult or impossible for the lawyer to give a client detached advice. Similarly, when a lawyer has discussions concerning possible employment with an opponent of the lawyer's client, or with a law firm representing the opponent, such discussions could materially limit the lawyer's representation of a client. In addition, a lawyer may not allow related business interests to affect representation, for example, by referring clients to an enterprise in which the lawyer has an undisclosed financial interest. So, Rule 8.1 goes into business transactions with clients, and Rule 1.10, you'll see, has to do with imputing conflicts of interest to lawyers at the same firm. But in Rule 1.10, it says personal interest conflicts under Rule 1.7 ordinarily are not imputed to other lawyers in a law firm. So if there's a conflict of interest in the sense where it's just a personal matter to the lawyer, other lawyers in the firm do not, under Rule 1.10, have that conflict of interest imputed to them if it's a personal interest conflict. And that was part of a question in this week's discussion in chapter 12's discussion questions, or maybe it was in the multiple choice. All right, Rule 1.8. Rule 0.18 has to do with entering business, so conflict of interest, current clients, specific rules. Okay? So Rule A, a lawyer shall not enter into a business transaction with the client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless. All right, so there are exceptions to this. That's the general rule. The transactions and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. So if you're going to enter into a transaction or an ownership interest that is pecuniary or adverse to the client, has to be in writing, and they have to be able to understand it. The client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel on the transaction. So it has to be in writing, it has to be understood by the client, and you have to give them advice to seek other counsel. And the conjunctive, all three of these must be met. The client gives informed consent in writing, signed by the client, to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. Okay, so those three things have to be there as an exception for when a lawyer enters into a transaction with a client or acquires an interest adverse to the client. Okay, the general rule, though, is don't enter into one. However, if you do, these are the three requirements that are met. B, a lawyer shall not use information relating to representation of a client to the disadvantage of the client unless the client gives informed consent, except as permitted or required by these rules. Now, B is it has to be to the disadvantage of the client. You may use information to the advantage of the client. C, a lawyer shall not solicit any substantial gift from a client. Okay? So you can't ask for a gift, including testamentary gift, meaning, hey, why don't you leave me your house when you die? Or prepare on behalf of a client an instrument giving the lawyer or a person related to the lawyer any substantial gift unless the lawyer or other recipient of the gift is related to the client. All right, so you can't ask for a substantial gift, including one in a will, and you can't prepare, for example, a will on behalf of the client where the instrument is giving you or someone you are related to a substantial gift. And they said, for purposes of this paragraph, related persons include a spouse, child, grandchild, parent, grandparent, or other relative or individual with whom the lawyer or the client maintains a close familiar relationship, so nieces, nephews. So related spouse, child, grandchild. They don't include siblings on there, huh? Maybe they don't expect siblings to be close. Okay, F. A lawyer shall not accept compensation for representing a client from one other than the client unless, now of course this happens a lot, this type of situation happens a lot in insurance situations where the lawyer is hired by the insurance company to defend one of their insured, okay? And that was one of the questions in the discussion problems or discussion questions in Chapter 12. It says a lawyer shall not accept compensation for representing a client from one other than the client unless, so there's, of course, you can do it as long as the client gives informed consent, there is no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship, and information relating to representation of a client is protected as required by Rule 1.6. So in the situation of when an insurance company hires you to defend one of its insured, these requirements have to be met. The client has to give informed consent, okay, and basically the client is going to give informed consent because, well, they're not paying for the attorney, okay, the insurance company is. 2, this is what gets sticky. There's no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship. You got to remember, if someone else is paying for it, they're going to be worried about their money being spent, okay, and what's going on in insurance. When it comes to insurance companies, they're going to have to pay out the awards or settlements. So what are they going to want to do? They want to keep it as low as possible. All right? So that could get sticky. It could interfere with the lawyer's independence because they could be saying, hey, they're going to get, for example, they're representing somebody in a car crash. The plaintiff says, we'll settle for $100,000. And the insurance company doesn't want to pay $100,000 in settlement. And they might be saying to the attorney, don't you think you can get less? Don't you think you can get less? And the attorney might be thinking, hey, this is a pretty good deal because if we go to trial, we might be paying a lot more than that. So this gets sticky. However, this happens every day in the United States because every day there are hundreds, if not thousands, of attorneys working for insurance or hired for insurance companies to represent the insurance companies insured. Okay, I. A lawyer shall not acquire a proprietary interest in the cause of action or subject matter of litigation the lawyer is conducting for a client, except that the lawyer may. So this one basically says, during the litigation, for example, if there is a piece of property that is the interest of or the proprietary interest, or if there's property that is subject of the cause of action, okay, the attorney cannot purchase it. All right. Now it says, except that the lawyer may acquire a lien authorized by law to secure the lawyer's fee or expenses. Okay. Still, that's not purchasing a proprietary interest in property that is the subject matter of the litigation. All right. That has to do with securing your fees or expenses and contract with a client for a reasonable contingent fee in a civil case. So, for example, the attorney could say, hey, if I win, if we win and we clear title to your property, how about you give me 10% of that property as my fee? And as long as that is a reasonable fee under Rule 1.5, that's fine. And again, that's not acquiring a proprietary interest during the litigation That's setting up a fee structure that if you win, you get the proprietary interest. Okay? All right, comment 1. A lawyer's legal skill and training, together with the relationship of trust and confidence between a lawyer and client, create the possibility of overreaching when the lawyer participates in a business, property, or financial transaction with a client. So what they're saying is, hey, we lawyers, we are so skilled and we have such great training, we could take advantage of the client. That's basically what they're saying. Okay, the rule does not, and that's if we enter into a business transaction with the client. All right, that's why they say, if you do this, they have to be fully informed. It has to be in writing, and you have to tell them that they should, or advise them that they should seek advice from another lawyer. All right, let's move on. The rule does not apply to standard commercial transactions between the lawyer and the client for products or services that the client generally markets to others. For example, banking or brokerage services, medical services, products manufactured or distributed by the client, utilities, services. In such transaction, the lawyer has no advantage in dealing with the client, and the restrictions in paragraph A are unnecessary and impractical. So if you have a client that owns a grocery store and you go in and you buy groceries from that client, you don't have to get that client's informed consent. You don't have to advise that client to seek independent counsel, and you don't have to get it in writing. Okay? Thank goodness, because life would be pretty rough if you did. Comment 5. Use of information relating to the presentation to the disadvantage of the client violates the lawyer's duty of loyalty. So if you can use information to the advantage of the client. Okay? So if you see a fact pattern where there's information that was gained during the representation of the client and it's being used, as long as it's not being used to the disadvantage of the client, you're okay. Now, of course, if it's information and it's confidential, you can't be spouting it out because you'll be in violation of 1.6. But paragraph B applies when the information is used to benefit either the lawyer or a third person, such as another client or business associate of the lawyer or family member as well. For example, if a lawyer learns that a client intends to purchase and develop several parcels of land, the lawyer may not use that information to purchase one of the parcels in competition with the client or to recommend that another client make such purchase. So that's a pretty good example. The client's going to purchase something. You don't want to go ahead and purchase it first and then, hold the client hostage and say, hey, I'll sell it to you, but it's got to be for a higher price. That's putting your client at a disadvantage based upon information that you learned relating to the representation. Okay. All right, let's move on. Comment 6. All right, this is about the gifts. And you had a discussion question in your reading concerning this. A lawyer may accept a gift from a client if the transaction meets general standards of fairness. For example, a simple gift such as a present given at a holiday or as a token of appreciation is permitted, like a framed picture, if you like the frame. If a client offers the lawyer a more substantial gift, this is allowed if the client offers the lawyer the gift. Paragraph C does not prohibit the lawyer from accepting it, although such a gift may be avoidable by the client under the doctrine of undue influence, which treats client gifts as presumptively fraudulent. So there might be an example where you could be, I don't know. I mean, there's some undue influence that you're placing upon the client, or even if you're not, I guess, because the presumption is that a gift is fraudulent. Okay, clients' gifts are presumptively fraudulent. So if they go in and say, hey, I want this gift back, the attorney asserted some undue influence on me during the representation, the court is going to presume that the gift itself was fraudulent, and the attorney will have to overcome that presumption. In any event, due to concerns about overreaching and imposition on clients, a lawyer may not suggest that a substantial gift be made to the lawyer or for the lawyer's benefits, except where the lawyer is related to the client as set forth in paragraph C. So it says if the client gives you a gift, that's one thing. But if you suggest a substantial gift, you're not allowed to do that unless, of course, you're related to the person. Comment 7. If effectuation of a substantial gift requires preparing a legal instrument, such as a will or conveyance, the client should have the detached advice that another lawyer can provide. The sole exception to this rule is where the client is a relative of the donee. Okay, in this example, if the client says, I'd really like to leave you something because of your long-time relationship that we've had, and you've always served me well, you've always given me good legal advice, you've always advocated well for me, and therefore I'd like to leave you something in my will. Well, you should say, okay, well, I'm doing the will for you, but you better seek the advice of another lawyer concerning this. That doesn't mean they have to take that advice, but you should give that advice. Of course, you don't have to do this when, it's a relative. So if you have a relative, you can go in and say, hey, I'll do your will for you, give me your house. And you can use undue influence on them as well, I guess. But probably you don't want to do that. Comment 8. This rule does not prohibit a lawyer from seeking to have the lawyer or a partner or associate of the lawyer named as executor of the client's estate or to another potentially lucrative fiduciary position. Nevertheless, such appointments will be subject to the general conflict of interest provision in Rule 1.7. So that's about concurrent conflicts or concurrent conflicts of interest. So there was a question about this, and it has to do with if you are doing a will for somebody and they're saying, who should I have as my executor? There's no one I can really trust. You should say, I'll do it. Or I have someone in my firm who specializes in this or who has performed, or whatever. You should name them to do it. Okay, that's okay. Comment 11. Lawyers are frequently asked to represent a client under circumstances in which a third person will compensate the lawyer in whole or in part. Because third-party payers frequently have interests that differ from those of the client, i.e. the insurance companies, including interests in minimizing the amount spent on the representation, i.e. insurance companies, and in learning how the representation is progressing, i.e. insurance companies, lawyers are prohibited from accepting or continuing such representations unless the lawyer determines that there will be no interference with the lawyer's independent professional judgment and there is informed consent from the client. All right, see also Rule 5.4c. We'll look at that towards the end of this presentation, or this supplemental presentation. I think we've also touched on this in the past, but Rule 5.4c, it prohibits interference with the lawyer's professional judgment by one who recommends, employs, or pays the lawyer to render legal services for another. Now, I think there's an example in your discussion questions, or maybe it's your multiple choice, about a pimp paying for the legal services of a prostitute. Comment 16. Paragraph I states, the traditional general rule that lawyers are prohibited from acquiring a property interest in litigation, during litigation. Okay, its basis is designed to avoid giving the lawyer too great an interest in the representation and avoid making it more difficult for a client to discharge the lawyer if the client so desires. Okay, if they each have an interest in the property, then they're both part of whatever if the property is the subject of the litigation, then they're both parties to the litigation. Okay, the rule is subject to specific exceptions as set forth in paragraphs E and I, and we went through those. When a lawyer acquires by contract a security interest in property other than that recovered through the lawyer's efforts in the litigation, such an acquisition is a business or financial transaction with the client and is governed by the requirements of paragraph A. All right. So if basically what that's saying is, if they acquire property or some other type of interest that is not the subject of the litigation, then paragraph E does not regulate that. Paragraph A does. Okay, contracts for contingent fees in civil cases are governed by Rule 1.5. And Rule 1.5 is the reasonable fees rules, and contingent fees in civil cases can be based upon, as I said earlier, if the subject of the litigation is real estate, a house, or land or something. The contingent fee can be, if the case is won, a percentage of that land, ownership and a percentage of that land. It's not always just money. Rule 1.3, organization as a client. Many of you will, at one point in your career, be part of an in-house counsel. And in that case, the organization is your client, not the person you work next to. Okay. A lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. And basically what that says is that, look, you represent the organization, but for example, Samsung doesn't act on its own. Its duly authorized constituents act on the organization's behalf. All right, so vice presidents, presidents, all those. All right. B, if a lawyer for an organization knows that an officer, employee, or other person associated with the organization, i.e. the constituents, is engaged in action, intends to act, or refuses to act in a matter related to the representation that is a violation of a legal obligation to the organization, or a violation of law that reasonably might be imputed to the organization, and that is likely to result in substantial injury to the organization. So if all those things occur, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization, not in the best interest of the person who's causing the problems for the organization, but in the best interest of the organization. Okay, and it says shall proceed as reasonably necessary. Okay, so for example, that doesn't mean you go to the Department of Justice or you go to the police right away. All right, so unless the lawyer reasonably believes that it is not necessary in the best interest of the organization to do so, the lawyer shall refer the matter to higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by an applicable law. So for example, if someone is doing something wrong, you probably should go to them first, and if they won't do anything about it, then you go to their boss. And then if that boss won't do anything about it, then you go to their boss. And if you run out of bosses, then you go to the board. Okay? And of course, if the board doesn't do anything about it, then we'll see what the rule tells you. Okay? But first things first, you don't go run into the cops first. Okay? You should proceed as reasonably necessary in the best interest of the organization, because that's who you represent. Okay, except as provided in paragraph D, if, despite the lawyer's efforts in accordance with paragraph B, if you act reasonably in the best interest of the organization, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action or refusal to act that is clearly a violation of law, and the lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, reasonably, then the lawyer may reveal information relating to the representation, whether or not Rule 1.6, that's confidentiality rule, permits such disclosure, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. So we went back for B, 1.13B, they have to proceed reasonably, have to go to the authorities within the organization. And 1.3C says, well, if that doesn't work, then this is what you have to do. And that includes, if necessary, to prevent substantial injury to the organization, to reveal confidential information to prevent such. And then we go to F. It says, in dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, A lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. Basically, that rule is saying, hey, if the constituents or the person who is doing something that could substantially injure or is talking about doing something that could substantially injure the organization, you have to point out to them that you represent the organization, not them. All right, let's go to comments. Well, comment 1, an organizational client is a legal entity, but it cannot act except through its officers, directors, employee share, and other constituents. Okay. That's pretty much, comment 1 is pretty much section A of 113. Comment 3, when constituents of the organization make decisions for it, the decisions ordinarily must be accepted by the lawyer, even if their utility or prudence is doubtful. So this, I think, is the business judgment rule as it applies to in-house counsel. So if they're not doing anything illegal, that could substantially injure the organization, or that is substantially adverse to the organization, then you can doubt their judgment, but it's not something in which you need to take reasonable action. Okay, decisions concerning policy and operations, including ones entailing serious risk, are not as such in the lawyer's province. Okay, paragraph B makes clear, however, that when the lawyer knows that the organization is likely to be substantially injured by action of an officer or other constituent that violates a legal obligation to the organization, or is in violation of the law that might be imputed to the organization, the lawyer must proceed as is reasonably necessary in the best interest of the organization. As defined in Rule 1.0f, knowledge can be inferred from circumstances, and a lawyer cannot ignore the obvious. So comment 3 says, look, when they're making legal business decisions, okay, when they're making legal business decisions, you're not to say, you're not to take, you don't have to proceed as reasonably necessary in the best interest of the organization to protect them from these business decisions. However, if they're going to violate the law or the legal obligations of the organization, that's when you have to step in, because the organization is your client. Okay, comment 10. There are times when the organization's interests may be or become adverse to those of one or more of its constituents. In such circumstances, the lawyer should advise any constituent whose interest the lawyer finds adverse to that of the organization of the conflict or potential conflict of interest, that the lawyer cannot represent such constituent, and that such person may wish to obtain independent representation. Care must be taken to assure that the individual understands that when there is such adversity of interest, the lawyer for the organization cannot provide legal representation for the constituent individual, and that discussions between the lawyer for the organization and the individual may not be privileged. I say this is basically saying you're on the side of the organization. If there's a constituent that is adverse to it, if they're doing something illegal, there's the discussion question concerning the Sarbanes-Oxley legislation. So if they're violating something like that, if they're violating the Sherman Antitrust Act or something like that, they are adverse, okay, to the organization and the interest of the organization. And basically, you represent the organization, not them. Okay, so when there's an adverse position, and therefore, it even says that discussions between the lawyer for the organization and the individual may not be privileged in such situations. So they have to be aware of that. There are comments, though, that in times where the organization and the constituent are not adverse, then you can indeed represent a constituent. All right, Rule 1.10 is the imputation of conflicts of interest. Okay, this is imputing conflicts of interest within a law firm. Okay, so while lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rules 1.7 or 1.9. 1.7 is the concurrent conflict of interest. 1.9 is about duties to past clients. Okay. However, it says unless the prohibition is based on a personal interest of the disqualified lawyer and does not present a significant interest of materially limiting the representation of the client by the remaining lawyers in the firm. So this is specific to your discussion question or multiple choice questions in Chapter 11. The personal interest of a lawyer in a firm will not be imputed to the other interest of a lawyer. Will not be imputed to the interest of the other lawyers in the firm. And we talked about that earlier. Okay, lawyer as a witness. Again, this was part we've gone through this before, so this is review. But this was brought up and implicated in the discussion questions and/or the multiple choice questions in Chapter 11. It says a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue. Okay, the fact pattern will normally say it will normally indicate whether the testimony will be based on an uncontested issue or it will be based on a contested issue. Okay, so for your MPRE and exam purposes, you have to look for that. The testimony relates to the nature and value of legal services rendered in the case. Okay, so if they're going up there and say this is I think this is an example of when the court can award attorney's fees and costs. Okay, so the attorney during that part of the trial, the cost and fees part of the trial, will be able to testify about the services that they rendered. Disqualification of the lawyer would work substantial hardship on the client. So this seems like a catch-all. Well, even if it's a contested issue and it's not about fees and services, if the lawyer would have to step down as the attorney for the client and a substantial hardship would ensue, then they can still remain as the advocate at trial. Okay, B, a lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by Rule 1.7 or Rule 1.9. And that also, 3.7b, is also implicated in your discussion questions and multiple choice questions in Chapter 11. I think this is the last slide. This concerns law firms and associations, and this is professional independence of a lawyer. We touched on this earlier concerning about when a third party is paying the fees for your client. It says a lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal service for another to direct or regulate the lawyer's professional judgment in rendering such legal services. Okay, so I think that's review from earlier in this presentation, and I think also a review from earlier in the year. Okay, so that does it. Hope you enjoyed it. We will be seeing you soon. 44 minutes, not the best, not the worst. God bless.